My fellow citizens, at this hour, American and coalition forces are in the early stages of military operations to disarm Iraq, to free its people, and to defend the world from grave danger. We come to Iraq with respect for its citizens, for their great civilization, and for the religious faiths they practice. We have no ambition in Iraq except to remove a threat and restore control of that country to its own people.
Hi, my name is Inder Comar, and I'm counsel of record in the Saleh v. Bush case. I represent Ms. Saleh in her case against members of the Bush administration regarding the legality of the Iraq War. I met Ms. Saleh through mutual friends in Jordan. She had been living in Iraq her whole life. She lost everything, like a lot of Iraqis did when the war started. So yeah, she had fled to Jordan with her family and was forced to leave everything behind. So it's with great pleasure that I'm sitting here with the plaintiff in the lawsuit, Champalaune, we're in Amman, Jordan.
أنا سعيدة لأنه شخص مثل حضرتك يعني مهتم قضية العراقيين وقضية إنسانة ل5 أولاد تريد تعيش.
Can you describe, when the war started 10 years ago, can you describe what the situation was like for you and for other Iraqis?
موت كل ساعة نشوف الموت كل لحظة ماكو استقرار ماكو حياة ماكو أمل كل شيء اللي بنيته بسنين وتعلمته كل شيء اندثر بلحظة قدام عينك.
If that were to happen to you or me, I think we would absolutely be thinking, what can we do about it? Because it's a terrible thing, and especially in a situation where there was certainly illegality running up to that decision to invade. The war in Iraq was illegal because it had not been authorized by the Security Council, and it was not a war conducted in self-defense. And under international law, those are the only really two grounds that a country can invade another country. There seemed to be a way to do this. There seemed to be laws that Iraqi refugees could utilize, or Iraqis victims of the war had redress. And it had never been done before in this way, but it was. It seemed to me very obvious that this was a case. Like, this is a case that could make a big difference. Mm. That's why I took it. Amongst other practicing lawyers or people I knew, I think people all thought it was a little out there, honestly. I don't think they were prepared to think about what it was I was really saying, or what this case was really saying. I mean, someone said the case was dangerous. I thought, what's so dangerous about it? And they said, well, you're going to open the floodgates to victims' lawsuits every time we fire a missile or do anything. I was like, well, maybe that's not a bad thing. Maybe we'll take a little more time to think about when missiles are getting fired. So her case was a case against 6 of the highest-ranking U.S. officials from the Bush administration. So that, in order, it was George W. Bush, it was Richard Cheney, the former vice president, Colin Powell, the former Secretary of State, Donald Rumsfeld, who was former Secretary of Defense, Condoleezza Rice, who was the former National Security Advisor, and finally Paul Wolfowitz, who was the former Undersecretary of Defense. We filed an initial complaint, and then we served the complaint. We were scheduled to have a court hearing today in the Northern District of California, and last week the court actually canceled the hearing. It's called a vacated hearing now. The Attorney General filed a paper saying these people were acting in the lawful scope of their employment, and the case should be dismissed and they should be immunized. And so that's what we had to battle. We filed a second complaint. So we're waiting on pins and needles to see what happens next, and we're very excited to see how the court will rule. Hopefully it could come down any day, and when it does, we will definitely let the world know what this court has said. And then that was dismissed with prejudice, meaning that was it. And so then we did that, and we filed an appeal. And that got some media, and that's when lawyers started to initially reach out. And that's when Don Ferenz reached out, for example.
He persuaded me that even if we would lose the case, the publicity around the case and getting briefs filed in federal court on the question of whether the actions of the United States government were in fact illegal in violation of international law might be helpful to potentially deter others who would become victims to this type of lawlessness.
We were at an international meeting together. We were sitting next to each other. We began talking about how illegal and harmful the Iraq war was, and he told me that he was thinking of filing a lawsuit on behalf of Mrs. Saleh and asked me if I would be interested in helping, perhaps filing an amicus brief, and I said absolutely.
I looked a little bit at what he was arguing, and I thought that this is a case that we could valuably weigh in on. And we got together a group that included the former Attorney General of the United States, Ramsey Clark, and a number of people were involved in this case that are experts in international law and that share our interest in ensuring that the rule of international law is respected.
It was great to show the court that we had a lot of lawyers and a small army, as I like to call it, but a small but mighty army. But and it was great. I mean, it was also some small vindication for me that other lawyers were taking notice, and that my theory wasn't so crazy, and that maybe this was the way to do it. What we've done last week, and I'm thrilled to actually be able to announce this, is we filed our appellate opening brief before the Ninth Circuit Court of Appeal, and after that, we will keep all of you updated. Thank you very much. The Ninth Circuit gave us a hearing and permitted us to show up. They put it on video, and they really took it very seriously and gave, I think, the issues some thought, which is what we wanted, which is exactly and all we wanted, really. The oral argument took place December 12th, 2016. It was cold that day, I remember having to bundle up, and we had some coffee and tried to relax a bit. And you walk in the courtroom, and then there's they have an electronic calendar of what's going to happen that day. And that's when it really hit me, because we were on the electronic calendar. You see it, the case, Saleh v. Bush, et al. And we were last on the calendar, which I thought was a good sign, last on the morning calendar. And then, we sat down, and then when it was our turn, the podium's in the middle, so you walk up and you get to the middle, and then there were, three judges, so it was, I want to say it was Judge Graber in the middle, Judge Hurwitz was on the left, and then Judge Boulware was on the right. And, they're definitely elevated. So they're sitting, you're looking up when you're talking to them.
Let's get to the chase. As I read the cases, a federal employee's actions can be pretty darn wrongful and still be covered by the Westfall Act, still be part of their employment, and therefore subject to the immunity of the Westfall Act.
The Westfall Act was really intended to protect officials that do things minor within in their activities, and it's illegal, like speeding when they're trying to get to an appointment very quickly, or parking in a place, or possibly causing injury to other people, but not killing 1.5 million people.
It says, effectively, that an employee of the United States government can commit murder, torture, rape, and violations of the highest level of what is called Jus Cogens law, the highest level of customary international law. They can commit violations of this law in their capacity working for the United States government, and it is still considered to be covered and shielded by the Westfall Act.
Part of the job of each of these individuals was to conduct the foreign policy of the United States, and that's what you're suing them for, including the decision whether or not to engage in military action. That's actually part of their job.
So then I got off the stage, or the podium, and then Curtis went. Curtis used his 5 minutes.
Please, the court. I am Curtis Tobler, representing the Amicus Curiae, Lawyers for International Law. This is not your customary tort. This was an action that destroyed the lives of millions of people. We argue that the Westfall Act should be interpreted in relation to that particular phrase, scope of office, as not including actions which are violations of jus cogens.
Then there are some rules of law that are so important that those rules can never be derogated from or never be violated. Those are jus cogens rules of international law.
No country can pass any laws that allow Jus Cogens violations, and there is no immunity for violation of a Jus Cogens norm. And the waging of an illegal war of aggression is a Jus Cogens norm.
Then so he spoke, and then it was the Deputy Attorney General for the defendants, and this gentleman got up.
We'll hear next from the United States. Thank you. What if they found the personal diaries of the defendants that said, I vow when I take office, no matter what the circumstances, to wage a war of aggression? What would be the outcome then?
I think even in those circumstances, if the reason that they vowed to wage this war was because they thought it was in the best interest of the country, then that would satisfy the third prong. So I don't understand why that would take it.
Because it sounds like you're saying no matter what would, in your view? Can you give us an example of where the limit would be?
Is where an individual is going to personally gain, for example, financially from doing something, and where that's the motivation for taking the action. But here, we don't have any allegations of any financial gain that these individuals were seeking to profit from in engaging in war, and certainly nothing that satisfies the exacting DC standard, which is solely for personal benefit.
And then it was my turn again, and then I tried, keeping notes and keeping track of everything.
One of the things that counsel mentioned was this kind of best interest of the country prong. I guess we talked briefly on the scope of DC law in terms of what counts as a personal motivation. I don't think the DC courts don't say anywhere that it has to be purely financial ever. They don't say that, especially again in the assault context, there is certain conduct that people can do that points in the direction of a personal motivation. But can you ever have purely personal motivation when the Congress of the United States authorizes the war? We allege the executive branch engaged in misrepresentation to the Congress. Congress passes a bill. They go out and do what they want to do. I mean, that seems to me like pointing in the direction, again, of some type of personal motivation that would require the court to analyze that at least, or look at those cases.
I try to focus on the fact that a financial interest is not a personal, a personal interest could be more than just a financial interest. It could be a lot of other things, and that was it. Well, I was sick actually that week. I was very sick. I was under the weather. And I got it on my email. I saw that there had been an order. And I saw in the email it tells you, affirmed or denied or reversed, or it tells you if you won or not. And it said I lost, right? So the opinion was affirmed. And I was like, there we go. So it's done.
The Ninth Circuit, by their decision, violated international law. because they refused to provide redress to somebody who had their rights violated under international law and under a non-derogable provision of international law.
The Ninth Circuit did say that the Westfall Act would not provide immunity to federal employees if they violated the Constitution. Apparently, the three-judge panel of the Ninth Circuit forgot about the Supremacy Clause of the Constitution, which says that treaties shall be the supreme law of the land, and that means the violation of the UN Charter, which is waging a war of aggression, is a violation of the Constitution, because the UN Charter is part of the Constitution since it's a treaty and part of the supreme law of the land.
You only get so many bites at the apple, so to speak, and this was a long process. It was a 4-year process, right? So to come that close to having a court and judges really review this and to not get the outcome you want, I think is heartbreaking. I still think about it every day and about anything I could have done differently, or arguments I could have made, or anything I could have done differently. The courts kind of washing its hands of that is a scary reminder that the U.S. can really, as a government, can really do what it wants.